All right. Half a day and good morning, everyone. Welcome to the Guam Legislature, the Guam Congress Building. We're very happy that you can join us today. For everyone in the audience and everyone at home viewing, today we are having an elder law presentation provided to us by the public defender um, this morning. And from the Public Defender's Office, I'd like to welcome Attorney Stephen Hattori, the Executive Director Kathleen Moylan, and Special Projects Coordinator Leslie Estrella. And I'd also like to mention that this morning we have a representative from the Department of Public Health and Social Services Bureau of Senior Citizens. Ms. Shar is here as well. So I'd like to again thank you all for being here and for being interested in some topics that are relevant to all of you and those who are viewing at home as well. So as a part of Senior Citizens Month, we know that we love to celebrate our Manamku and do lots of fun things, but we also wanted to provide some services to you that can be useful in your day-to-day life to help you to understand some common legal issues that you may be facing every day. So we have the Public Defender's Office who will do a short presentation for you, and then we will open it up for Q&A. And many people know that the Public Defender, they're there to provide services for criminal defense work, but their large mission, as referenced in their name, is to defend and help the public in legal matters, to include civil matters, which is part of the mandate of the Public Defender's Office. So in fact, in the last legislature, Senator Therese Terlahi introduced a bill that was passed into law that allowed the Public Defender's Office to help service those who had questions with their WAR claims, who needed to submit that application. And so they've already been assisting our Manamko, and we want to further expand these services and allow them to answer any questions that you may have today. So right now we're just going to set up the room. Those of you who are here, if you'd like to come up and sit at the round table, and then the public defenders representatives will sit here, and then we'll have a very informal kind of presentation and Q&A that will also be available for the viewing public. And then if you'd like to reference it again later, it will be online on our YouTube channel. So Suduas Masi all for coming, and I hope this is a very productive and a day that we get a lot of our questions answered. And I'd like to also recognize here our Committee on Rules Chairperson, Senator Regine Biscoli, for being here and of course supporting all of our Manamko events throughout this month. And I know I saw many of you at our legislative reception, so I'm again happy to see you here today. We've been celebrating all month, and now is the day to be a little bit more serious. So I hope that this is all very helpful and informative for you. So Sitios Masi.
represent criminal defendants. But if you look at our statute, and when we were first created, we were also required to provide legal services for civil matters for people who financially qualify. So in the past, historically, we've done all the things that we're going to talk about today: power of attorneys. We've done living wills. We've done wills. We've also done probate matters in the past. But currently, we're not able to perform those duties. And the senator did mention, Senator Terlahi passed a bill last year regarding the war claims. And so when that money starts coming out, of course, hopefully you guys are all alive so you can claim it yourself, right? But if someone has passed away and they're entitled to a war claims money, they can come to our office, and there's an expedited process where we will provide, we will get the money released to them without any cost to them or their estate. So ordinarily, it would have to be part of their probate, and it's a costly and lengthy procedure. But Senator Terlahi in the Guam legislature passed a law that would make it, really expedited. So it would just be an affidavit, some consents from the heirs, and then we could just file it at court, and then with that, you can get an order, the money will come out, the court won't charge you a fee, the lawyers won't charge you a fee, and it can go, it's a nominal amount, but you'll get all of it. So the legislature approved that last year. Unfortunately, it won't take effect until the money starts getting released, okay? So that's a little bit of the background that we've been doing lately, helping the seniors. I know that, as a senior, right, you have many concerns as you age, right? I mean, like, what's going to happen with your property? Who's going to take care of you? I mean, there's so many things that you have to think about. I know, I'm going to be a Manamco soon, in like 5 more years, so I'll get discounts at the movie theaters. But I'm already starting to, personally think about those issues. And I had a father that had a stroke, and there were 9 kids. Everybody came back, and we're sitting around the hospital, and he was in ICU, and he didn't have a living will. He didn't have a power of attorney with a durable power of attorney. So, there was really no decision made by my father. So the family really had to make the decisions. And so, of course, we decided to, keep him on life support. Eventually, he pulled through, and he never fully recovered, and he had a stroke. He was living with a stroke for like 5 or 6 years. So, so that's, I know it's a real big issue for all of you, and for all seniors, really, they really should look towards taking care of these issues so their children, the loved ones that they leave behind, don't have to deal with it in an emergency type situation. Okay, let's begin with our first topic. So in planning ahead for your future, right, it's not too early. I'm not sure, does anyone have a power of attorney? Has anyone give a power of attorney out to anybody? Okay, so generally a power of attorney authorizes somebody, your agent, to do certain things on your behalf. And they can do many things for you. They can, buy or sell things. They can apply for public benefits. They can obtain your medical records. They can collect your debts. So like if you're a landlord and you go visit your child in California and you stay out there for a few months, you can appoint someone to collect your debt. And if, you have to evict them, they could sue to have your deadbeat tenant, evicted from the house, okay? So a power of attorney can do so much more for you. Like they can deposit your money for you, they can withdraw money from you, they could sell your property, manage all your assets. And so it's a very good tool, but it's also a very, dangerous tool. It's very prone to abuse. So general power of attorneys are generally disfavored among lawyers. Like lawyers would generally advise you against a general power of attorney. And so they have a thing called special power of attorneys. And a special power of attorney limits what an individual, your agent or your attorney in fact can do for you. So for example, you can say, I'll give you the power to collect rent and to manage my property, but I do not authorize you to sell the property or to lease it out for, an extended period of time. Okay, so that's something that you want to keep in mind when you do it. If you need a power of attorney, it's very convenient because then you don't have to go to the bank, right? You could send your oldest son or your oldest daughter or whoever you give it to, right? They can go prepare and file your taxes for you so you can just stay home and take care of your garden, right? So, I mean, there is a benefit to it, but you have to be very careful and select the proper person to do that, okay? Now, power of attorneys also, if it's going to involve real estate, those really need to be notarized and they should be recorded at land management so that it's recorded. You know, all our property, anytime there's a deed, right, it's not effective until it's actually recorded at land management. So if a power of attorney involves real estate, it should be recorded at land management. And of course, you know, that's a very dangerous thing, right, to give someone a power of attorney over your own real property. It has, I mean, I know that nobody here has a power of attorney, right? So, but there are examples where people would encumber property or sell property through a power of attorney. And if that happens, you know, there's not much you could do about it. Okay? So just be careful with that. And if you do revoke a power of attorney involving real estate, be sure that that is recorded at land management. I think they charge like 25 bucks. I was surprised. I thought there was a waiver for the Monumco, right? Or indigent people, like if you're, you know, indigent and you can't really afford the filing fee. But apparently, maybe that's something they could work on in the future, like a waiver of fees for seniors. In fact, even, well, we'll talk about that later. Even probate matters, there's closing costs that seniors have to pay to get the property released. And, you know, I mean, that's something they can consider a waiver of the closing cost fees charged by the court. Now, the power of attorney, if it's a special power of attorney, if it's too specific, then it won't be able to do everything that you might want it to do. All right, so that's why if you do a special power of attorney, you have to make sure it includes all the powers you want them to do. For example, like if you want them to be able to sell your property or rent your property out, then it has to specify both sale and rental. And so that's why sometimes, you know, people say, you know, power of attorneys, they have forms floating around, and you could do one yourself without the use of an attorney. But if you have a lot of property or if you have specific wishes, you might want to have an attorney look at it just to make sure it complies with what you want. Now, power of attorneys, right, they take effect usually immediately unless the power of attorney specifies when you want it to take effect. For example, if you're going to go off island for several months, you could specify that this power of attorney is good from the date I leave until the date you return. So if you're going to go off island for 6 to 9 months, you can specify that it'll be only valid during your absence from Guam. And it's always good to put the specific date. If you're going to do it every year, then there's ways of drafting it so that it'll apply only when you're off island. Okay, so that's something else you will want to consider. Guam also has a durable power of attorney law, and what that means is ordinarily a power of attorney, it basically only exists as long as you're alive, or if you're disabled, it automatically terminates a power of attorney. So if you give a general power of attorney or special power of attorney to a family member and you become incapacitated, without a durable power of attorney, that individual cannot make medical decisions for you. So if they just have a regular general power of attorney and you need a certain surgery, they can't use that power of attorney to tell the doctor, I approve this surgery for my principal. So Guam created a Durable Power of Attorney Act, and what a Durable Power of Attorney Act basically says is that if I should become incapacitated, then this power of attorney is still valid, okay? And so they could still manage all your property, they could take care of all your bank accounts, they could take care of all your, you know, property, whatever, while you're incapacitated. And they could also make medical decisions for you. But that's a clause that you would need to put in the power of attorney, like if I should become incapacitated or disabled and unable to make a decision for myself, then my agent or my attorney, in fact, can make a decision for me, a medical decision for me. So that's a durable power of attorney, and it can be attached to a general power of attorney as a clause, or it can be attached to a special power of attorney uh, as a clause. And then, but later on, we'll talk about a special durable power of attorney for healthcare. But we'll get to that later. Okay? And you guys know all the risks involved in giving someone a power of attorney? I mean, basically, this person is like, can do everything that the power of attorney gives them, like sell property. Uh, they can access your bank accounts if you authorize them to do that, which means they have the power to remove all the assets in that bank account. And I mean, they could, that's why you have to be very careful who you give that to. And if you do revoke a power of attorney, you might want to, you know, give notice to your banks that you've done that, so that this individual can't go back and continue to deplete your bank accounts. And that's why if you ever see, like sometimes in the newspaper, there's an article or a little ad that says so-and-so's no longer affiliated with the company. And that's the kind of notice that companies give out when they have an employee that might be saying that they represent the company. You don't necessarily have to take out an ad. You just need to let the person that you gave the power of attorney know that it's been revoked. And then also, just to be safe, let your banks know as well. Okay? Is that something that anybody here would want to do, like have a power of attorney? You're interested? Oh, sure.
I've gone through like 2 months ago. I used to accompany my brothers and my sisters when they're on Guam, and I have to take them to some legal offices and send them back to the States. But then when I went out about 3 months ago, and the office in Agana, in the Agana, whatever it is, it used to be giving out pamphlets, when you come there to their office, and then they'll help you out. Because according to the Elderly American Act, you're disabled in doing things, when you reach certain, and that's one of the things that I want to be explained. Please, in the Elderly American Act, I know Department of Labor has a book like that, but to be defined out so that, when we get older, even if we have so many children, sometimes they don't want to be bothered, sometimes they're too far away from us, and there are many things that we become incapacitated if we reach certain age. Limited because we're sick, limited because our thinking capability, our physical body, are not able to function the way they should. So I'm having that problem.
So,
Because I used to help out my brothers and my other sisters. But when I came there down to the office, 2 months or 3 months ago to seek for help, they told me they no longer carry. So they told me to go to another office. They no longer carry. I went to Manila, and I asked a person there, Regis, I don't know what's his first name, but I said, where are you from? He said, from Rizzo. And I said, who are you? So he told me. I said, what is happening with this Elderly American Act that they cannot help now senior citizen? So the minute I heard this on the radio, I said, oh my gosh, I need to go there because there's so many things that we're entitled as elderly. And I wish, and you great people, I'm very grateful.
yeah,
The minute I heard this, I asked my friend, can you please take me, can we go down there because I need to have things clarified. I'm
and,
educated enough, not that I'm bragging, but I'm educated enough to the point that I can comprehend, to share. But now they're limiting the share because the office now, those lawyers are no longer taking, business for the benefit of the Elderly American Act. So where do we go
Well,
from
and
here? Who can assist us?
yeah, and that, I mean, I think there's few enough of you here where I can personally help you because I do pro bono work. So I'll help you with your specific case. But generally, like, if an individual is still competent, then they can do a power of attorney with a durable power of attorney. But if they're already incompetent, like if they suffer dementia or something like that, where they
I don't
cannot
like
make
you.
decisions, then you would need an incompetent guardianship. And what that requires is that someone be appointed to be a guardian for an adult. And our office actually does incompetent guardianship. So if you have someone who needs, if you need an incompetent guardianship, you could come to our office and we do those as well.
There's some limitation to the accompanying guardian because sometimes it becomes our own children. And I wanted the lawyer to do it for me because, my daughter and my oldest son or whatever it is, if I tell them something, why is he going to get this? Why is he going to get that? So I really need to a person that
Yeah.
do not know my children so that I can, it's just that, things are changed now and it bothered
Well,
me because,
and they have, okay, so they have the Office of Public Guardianships, and they often serve as the guardian for adults if there are no available family members or if there's a conflict with the family. At our office, we could set up the guardianship, but we cannot serve as the guardians because we would be the attorney for the
can you
person.
make this more visible and more, so that most of these older people can know where you're located for help? Can you please help us
Sure.
out
I know we'll
in
work with
spreading out your
Arts
office?
and Augustine. I mean, he has caseworkers, and I think the caseworkers are aware that our office, that's one of the things that
Because
we
when
can
I
do
went to
is
that
that,
Oval office in Manila, and that was only about 2 months ago, they told me they're not doing it, so that's the problem. I cannot drive.
okay,
I
so,
have to ask somebody, so, where are some of those accessibility
and
that we can,
we'll work with, Art to get you the information you need.
please, if
Okay.
you can,
I
if you
know that
can.
some of our employees have gone out to talk with the caseworkers at the senior division to let them know that, our office, we're able to do protective orders. Our office is able to do incompetent guardianships.
Or can you
And
give the phone number so that, they can communicate and then, some communication process and things that will lead to assisting elderly.
yeah, okay.
And I will appreciate that, and I'm sure that most of these people
And,
that really need.
and that's why I'm appreciative that Senator Shelton invited us here so that, we can inform the seniors that we're available
Because
for
I
certain
prayed a
services.
lot, and I prayed for this assistant, to come and, oh my goodness, when I heard it on the radio, I said, oh my goodness, I'm grateful for what is happening now.
Okay, but after, make sure you sign up, and then one of our staff will put you in touch with me, and then I'll help you with
But do
your
you have
legal.
any handout that you can, a brief handout so that, we can have it with us and then call you on the phone and then,
Well, we have our office flyers, so you can get one from the front, and then just ask for me, and then I'll help you with that.
because I'm very sure that it's not only 10 of us or 20 of us, it will be, that plenty. Because this is what the senior citizens are suffering now. I don't go to centers.
Oh, okay, so that's where most of our information goes
Thank
through, I think.
And I
So,
think,
but the issue you raise is really important because if you have a durable power of attorney, then if you become incapacitated, they can still make decisions for you. If there is no durable power of attorney, then the courts will have to get involved.
but if you
and,
die when you have that durable, then you just die too. It is useless.
Oh, yes, a durable power of attorney will die along with the patient. But, and at that point, everything will go through probate unless you
Yeah,
take care of it
and the probate is
other
so
ways.
costly.
Okay.
I mean,
well,
anything in the unit, because I don't know why, maybe it's because there are many senior citizens now that are, like when I come to that Oval Office and they told me, no, they cannot. I said, where do I went to 3 offices of lawyers, and
Yeah.
it's all I need is, even myself, I can be going and helping, senior citizen. I don't drive, but I can work, but
No, I mean, I,
it's a
I under,
complicated issue. It's not easy.
yes, and I understand your frustration. I mean, at our office, we turn away people that we're currently not able to help, and it's really frustrating to us to not be able to do it. But the services that we do provide, we'll make sure that the seniors know what we can
Or
do for
just
them.
assign, like if they can assign one lawyer that will, like what they did in Agana before, but now,
Yeah, and we're working on that.
Thank you very much for that question, Auntie Rose. And so that's why we invited the Public Defender's Office today, and we put out this notice. And all of the information that Attorney Hattori is giving us today, it's also provided in these handouts, his contact information, and we'll also publish the information on our end so that we can share this with the broader public. Just as you said, the Manamku do need to know more about what services are offered, and so we will do our best to do that. Thank you very much.
Okay, and since you guys actually came down to the legislature and there's enough of you that I can actually help, I was worried there'll be like 100 people here, so I wouldn't be able to. I can't help all 100 of you. I'll have one of our staff members get your number, and then we'll call you up and set something up to see if we can, help you on an individual basis. I mean, I did do a couple wills just yesterday for a couple people that seniors, and so, I know that there's a huge demand, and we're trying to encourage other attorneys in our office to do pro bono work.
the service is there. So maybe we can go down to our nearest village, office, and
Well,
if you have the time.
and there was a time when, the public defenders, we were not currently we're under a moratorium that restricts us from doing these kind of services. Uh, but when we were doing it, we were able to go out. Like, I've been out to do wills at people's houses, and some places they were competent enough to understand what was going on, but they couldn't sign their name. So we
See,
bring
we
notaries with
organize-
us, and they do thumbprints. So, hopefully we can get back to that point where we're able to
If we
go
can
out to
organize
where the
something
services
and
are
we
needed.
go by group, or that certain group are trained to help out, it will lessen up your burden on your side. It will lessen up the burden of the Attorney General or whatever it is. But this is where the help really, like,
Exactly.
help
There's a
is
huge
needed.
demand for it, and we just want to be able to provide it. So we're working on it.
Because the problem that you can detect from all the families, if not most, if that you don't want the message to go out, that I'm going to give this to my son or this, that, to that. It has to be really digested in a way where, this work is going to be durable but helpful
Yeah.
for the rest of the family. Because I cannot even tell my daughter, that I'm giving this to my son because he's going to
Oh.
get angry at me. So these are some of the things that we would like to hear.
No, exactly. And that's why it'll be helpful, because it'll put your mind at ease, but it'll also reduce conflict and the potential for, families fighting after you're gone.
And,
So,
the thing about durable, there's certain things there that will just die when the person die.
exactly.
And so if you can make us understand, and I'm very sure that this is the most special request that the majority of the senior citizens here on Guam.
And that's perfect, because then it goes into our next topic, is estate planning. And so hopefully that'll answer some of your questions. Okay, but yeah, we will help you. I'll help you with what you need. Or,
So, Auntie Rose, for all your questions here today, I know that Steve will get your information and will coordinate to have him help you with some of your more pressing matters, okay? So thank you very much, Auntie Rose.
Thank you.
Okay, thank you. So the next topic is estate planning. And, that's really a very important issue for the Monomco, right? Like, what's going to happen to the property after I'm gone? And, it could also lead to a lot of conflict among the family left behind, right? Currently, if you don't, does anybody here have a will? Anyone? No one has a will? So, if you don't have a will, right, it goes through the laws of intestacy, and basically part of it goes to your surviving spouse if you have one. If not, it gets divided among the children equally. And I'm not sure if you're familiar with the Larry Hillblum case. Like if you have outside children, they'll be able to make claims as well. So a will can take care of all those things, and it could also help you basically make sure the property goes where where you want it to go. All right. I mean, I know like a lot of families, there's always one or two kids that take care of the sick.
If you find some of those, can you make it, like I said, there's so many different forms that they're using.
Well, yeah, and that's why that's something you really should consult an attorney with for if you're going to do a written will. See, there are two type of wills. One is a will that's executed with two witnesses and it's notarized, and the witnesses, they can't be heirs of the estate,
And
right?
who do we,
But-
can we go to the Attorney General rather than just going to a lawyer? Can the Attorney General help us out? Just clean up
The-
before, because, because the Elderly American Act, there's certain help that can be given to us.
Yeah, and I think like each individual person needs to meet with a lawyer separately to discuss their specific case. But I mean, in the meantime, you can always do like a holographic will. And a holographic will is it's in your own handwriting. It has to be in your own handwriting. It has to state your name and your date of birth and everything to identify yourself. And the entire will has to be in your own personal handwriting, and you could dictate who gets which part of your property.
You see, even that,
And that's valid, and that's a quick fix until you actually meet a lawyer. And so
even that, there will be many that will challenge that because many cannot write.
no, and that's the problem, the
And-
drawback with that. If you cannot write in English, actually, holographic wills can be in any language, so you could write it out in Chamorro too, as long as
Not even tomorrow, I don't know how to write.
somebody can recognize it as your writing. And that's the main contest with a holographic will is it in the handwriting of the person?
I'm so glad that you came up with this because I was dreaming about this for so many months. That somebody will come up and ease it down for the elderly to plan for what is the end of their chapter.
Yeah, I mean, I understand. I mean, the two individuals we helped yesterday, they actually said they were on a wait list for like a year. And so I really felt bad for them because if they had passed away during that year, then their wishes would not have been met. And so that's the main purpose of a will, is to make sure your wishes are met after you pass. And the problem is, and the best thing about a will too is like, if you do it properly and you execute it with a notary and there are two witnesses, you can file it at court, and the court you can deposit your will at court. It costs $50. And in the past, when our office did it, they didn't really charge us. But
Sometimes in court, like I had something and they said you can take it home and place it at your home.
yeah, you could place it in your home, and some people put it in safety deposit boxes. But then, when a bank finds out that you die, right, the first thing they do is they deny everyone access to your safety deposit box, so you can't really get it out.
That's all we need. We need just a guideline, an outline of what we're gonna do.
So, a proper will preparation should involve filing it at court. And so it'll get a will number and and then you give a copy of that to the executor, because you have to appoint someone to manage your estate. And then you give the will number for the pleading to the executor, and then they go to court with the death certificate, and then the court will release the will. So that's probably the best way of holding
Yes. Okay.
it. Okay. Oh, you have another question?
My name is Atilana Rambayon. I belong to the Astombo Senior Center. This is my first year to really participate in the Senior Month activities. And I'm very impressed. That's why, Mr. Art, I would like to make an appointment with you sometime. I am here today because I'm 80 years old. I'm pre-departure. I need to make decisions for my 3 children who are not here. So I, I tried to do all my homework for, permanently leave this planet because I'm 80. So I came here to learn how to do the holographic will because my issue now is the house. I've been asking around for consultation about what to do with it because I have 3 children. They are married, but one is a widow, which means she's single. So I asked if I can name all of them, and the lawyer that I consulted said that I can't because if I did that, it will complicate matters worse because they are married.
Yeah.
And so I need to learn how to do the holographic will. Like I heard you say that it has to be in my my handwriting,
Okay.
but I need the steps.
Okay, well, I think we're going to go into that next. And one of the things I was going to talk about was, what happens if you don't have a will? The first thing was intestacy, so you won't have control over how your property's just distributed. It'll go according to the laws, which would be like half to your spouse or divided among your surviving children and their children. And so, or if there's there also have community property petitions, like if all you own is a house that's community property, then of course it goes to your surviving spouse, right? So you might not need a will in that case. And then one of the other things that some attorneys recommend instead of a will is a deed of gift reserving a life estate. And so that might be something you want to consider, because if you only own like 1 or 2 pieces of property, then you can actually deed it to your children, but you reserve a life estate for yourself so that you have that home for as long as you live, and after you pass, it'll automatically go to them. The benefit of that is it won't go to probate. It'll happen automatically once they file the death certificate at land management. So like in your case, if you wanted to go to all your 3 children or one particular child, you could do a deed of gift reserving life estate where you keep the property as long as you shall live, and then after you pass, it'll go automatically to the person you want it to go to. And, but there are pros and cons to the deed of gift reserving life estate. I mean, it can't take care of your entire probate. So if you have money in bank accounts and everything, it won't really you can't use it to address those things. So that's why if you they have another mechanism for probate called estates of small values. So if your estate cost is like $75,000 or less, if you have that amount or less in a bank account or investment account, then you don't really need to probate it. It'll just be, there won't be probate you won't have to do a full probate. There's a expedited procedure for that. The problem with that also, it'll get divided according to the laws of intestacy. So that's why you might still want a will if you want to, say, exclude one child or give property or some of your assets to grandchildren or nieces or nephews or your godchildren. But a deed of gift reserving life estate can take care of single property estates, and then they really won't have to do a full probate of whatever's left unless you have other property that exceeds $75,000. Okay, but a will is always good because then you decide who gets the property rather than the law. Okay, so and the deed of gift reserving life estate, they have forms, but I can help you with that if you have questions. Okay, since you made your way all the way to Agana, we're taking a list of people, and as an attorney, the Supreme Court encourages us to do pro bono work. So since there's only like 10 or 15 of you, I can do that. All right?
I really
So
appreciate that.
our staff will take your names down.
Oh, thank you very much.
Okay, so the benefits of doing a deed of gift reserving life estate, you avoid probate. Um, the property, since you only own a life estate, it's not really subject to being foreclosed on if you should have medical issues. Like, for example, if you are committed to a hospital and you incur large debt, they cannot really attach your life estate because it really wouldn't have that much value, okay? And because it terminates upon death automatically. The other thing too is like if you give, there are certain tax benefits if you do a deed of gift reserving life estate, because then, like if you pass away, the estate would have to pay taxes on the increase in value of the property. But with a deed of gift reserving life estate, there isn't, they don't increase there isn't a taxable amount. The profit or the increase in value of the property won't get taxed. Okay, but of course there are problems with a deed of gift reserving life estate, right? You can't use that house to get a loan, right? So like if you have a deed of gift reserving life estate and you need a loan, you'll have to get whoever you gave the remainder to sign off on a mortgage, and they would basically have to end up co-signing a loan. So if you want to, go on a cruise for a year, and they probably won't let you use your life estate as collateral. You would have to get whoever you gave the property to sign off on it. Okay, and the other problem too is sometimes deed of gifts reserving life estate that are given to a child, and then it's the asset of that child. So if that son gets divorced, that could be an asset of the divorce. So when you do a deed of gift reserving life estate or any deed of gifts, you could specify that it's being given to them as their separate property, and that will protect it from being a valuable asset in the divorce, if God forbid there be a divorce, right? Okay, and so that's an alternative to doing a will. If you have less than $75,000, you're fine with the cash going to your children in equal shares, and you have one piece of property that you want to go to a specific person, then a deed of gift reserving life estate and then an estate of small value, those two things together can probably resolve a lot of your issues. But if you really want to have full control over what happens to your property, then of course it's best to get a will. And nobody here has a will, right? So that's something that you might want to consider. A will, you can do so many things with a will. You can direct who your property goes to. Some people think that I don't have any children, so I don't need a will. If you don't have any heirs at all, like children, or if you don't have any heirs at all, you probably need a will more than anyone. That way you can decide to give the property to like a church or a godson or a goddaughter or, someone who's a non-relative. So if you die without a will, the property is going to a relative. You don't have control over it. With a will, the property will go to whoever you want it to be. Okay, so I know some people even give their property to the church or other non-family members. Okay, so there's two types of wills. The will that I helped two individuals do yesterday was a will that was witnessed. You need two witnesses, and it was executed in front of a notary. The witnesses have to make sure that you're capable of, that you have testamentary capacity, which means you understand that you have property and that you're competent enough to decide who it's going to go to. Okay, and a will stays valid as long as it's not revoked. Okay, so like if you become incapacitated, you cannot change a will. Of course, if you die, you can't change a will. But you can change a will until you become either incapacitated or or you pass away. So it gives you the most amount of control over your assets. And that's a will that, I mean, they have forms for those. It's probably better to talk to a lawyer, especially if you have a lot of assets that, you know, if you have several homes and you want them to go to different people, because you can accidentally give it to the wrong person, depending on how it's drafted. You also have to exclude people that, you know, children that you don't know about. I mean, of course, you're all mothers here, so you know who your children are. But there are fathers out there that, you know, don't necessarily know who all their children are. The famous case was the Larry Hillblum case, right? Where he had outside children, and he was a lawyer himself, and he forgot to put in his will a provision that disinherits all known and unknown heirs that are not identified in the will. And that's just a common boilerplate language in a will, but if you don't put it in, then all the outside children could come in and get a share of the property. Oh, no, yeah, I'll help you with, I can't help everybody in the YouTube world, but I can definitely help the ones present today. Okay? Oh, we do have forms for wills that,
Mentioning now.
oh, okay.
And then maybe we can get some of those, and if you can make us a form so we can just write it in. Oh, we really appreciate your help.
Okay, well, that's one of the things that, see, there you have two types of wills. One is, you know, the executed will that is typed and requires a notary. And then they have a holographic will, the one where it's in your own handwriting. And so I can go over those, what's
The
required for a
reason why I'm
holographic.
asking you for some of those forms so we can fill it in, and then maybe if we want to change, we can get access on your office or whatever it is, you know, what do we do with this? But right now, it would be probably more helpful if we have the forms, so we can just plug it in, you know. And then
Okay.
any future changes, what do we do? You know, so that,
Yeah, and I think I was expecting you know, if since we have such a small group, we could even do an exercise if you want. I have one for the advanced directives. We have forms that we brought to, we can
we
go
need the
through it
form.
together. But I think, you know, to do something like a holographic will, we probably would need like a smaller,
I obtained some of the copies from Fishers and Associate, but, you know, it is not as lengthy as what I expect.
oh, no,
But when I went to Las Vegas, I found on the shelf, you know, and I have it at my house. But again, as what you're mentioning, there's so many things there that, you know, can change in a little time or a long time. So, you know, if you can think of what would be most helpful and, you know, thinking of the kind of people that you're going to be having. Like if you have one child, that's easy. But if you have so many children, then and if you have so many land, then that's a problem also.
yeah, and that's something that we, you know, we've talked about in our office about doing like little workshops. So that's something that it's a great idea. Hopefully we can explore that.
With your forms, it
Yeah,
will really
because I think
help.
you know, I mean, like, especially like holographic wills, those are things that if there were like a group of 10, 12 of us at a time, we could walk you through and you can draft it right there and then,
No, walking through, you know, I don't even have a typewriter, but if you have your forms, you know, we can duplicate it.
okay.
And then we'll meet again if you need us to meet again, and then you being our first-hand helper. And before we finish all those things, we can give it to the lawyer, but cleaning it from your,
Yeah, no, I'll be able to help you with that.
we will appreciate that very much.
So let me go into like the elements of a will. I mean, you know, of course, your name and place of residence. You have to list your assets. You have to identify all your spouse, your children, and your other beneficiaries. It's always good to recommend alternate beneficiaries. So like if you wanted to go to your oldest son, but if your oldest son shall pass, then you wanted to go to your second oldest or whatever. So it's always, you can always put conditions in there like that. Holographic wills or even regular wills, you can actually write a list of your assets, like if you have a bunch of jewelry and you want certain daughters to get this jewelry or that jewelry, you can write a list out and specify who will get those. You can direct that all your bills be paid out before certain parts of your assets are sold to pay off your debts. Uh, and you could also specify which assets are sold first. So like if you have like a property in Utah that you bought like in the 70s when they were like $2,000 for 10 acres, you can sell that, you can direct which property gets sold first. Okay? In a will, you can also direct like who would be a guardian for your minor children. I know, of course, hopefully we're not still bearing children at our age, right? But Guam is really known for grandchildren adoptions. Does anyone have a grandchild they adopted? I mean, there are a lot of grandchildren adoptions out there. So if you have a grandchild that you adopted and you pass away, right, that child will need a guardian. And oftentimes it'll be the biological mother who, at that point, they're like siblings because they're legally adopted. But if that's not the case, then you would be able to specify in your will who you want to be the guardian for minor children. And it happens more often than people realize because, Guam, there are tons of grandchildren adoptions out there. And then, of course, your signature and your witnesses. You basically need 2 witnesses. I know that most law firms use their staff as witnesses. And then we prepare an affidavit of subscribing witness. So the witness would, at the time the will's executed, would say like, I observed this individual, they appeared competent and able to execute the will, and then that's stored along with the will. Gets deposited at court. It's like $50, and then upon death, it will get released to the executor. And that's something that you also need to contain in your the will. Who do you want to be the executor of your estate? Most people put their spouse. A lot of spouses don't, especially might not survive the wives, because you women will probably all outlive your spouses, right? Because you know how men are, right? They eat bad and they don't go to the doctor. So you can always appoint, a trusted child or a trusted family friend, and always appoint like an alternate executor. Because if you don't appoint an executor, or if an executor is disqualified, then there are certain laws on who gets to be appointed executor, and you might not necessarily agree with who the court, wants to perform that role for you. Okay, so when you're preparing your will, of course you have to first get an inventory of all your assets, and these are main assets like real property, your car, any trusts, investment options. Some people will actually get a list of their jewelry, or if they have a bunch of nice purses or items, special items, it's always good to put those in a list and specify who's going to get that, because you don't want your children fighting over like who gets which pearl necklace or whatever. Okay, and so once again, wills are valid until they're revoked. You can always revoke it either by tearing it up, or if it's at court, you can actually have the will released to you and then destroy it. Or you can also update it as you need to. If you get new property, you might want to make you would have, like say you already have a will and then you buy another property, you might want to specify who that property would go to as well. Okay? Of course, you have to keep the will somewhere safe. I recommend filing it at court. It's a very nominal charge, and it'll give you peace of mind, right? If you keep it at home, someone might read it, not like what it says, and then destroy it, or they might not be able to find it after you pass away if you hide it in a very good spot. If you, some banks might not let you have access to a bank, a safety deposit box after you pass away. Right now, the banks seem to have access relatively quickly. So once they find out someone passed away at the hospital, if you've been letting someone use your bank account, like with your ATM card, they'll likely not get access to it like within a day or two. So I mean, the banks are really getting good about that. Okay, so that's basically a written will. Guam also has a holographic will statute. That one is gonna.
Is it legal for you to video yourself for in substitute of a will?
Is it legal to what?
Legal, to honor it. If you put yourself in a video
Oh, yeah.
and,
That's
and
like a-
stack it someplace that your kids could look at it.
Guam doesn't really have a specific video will statute, so, but I'm pretty sure a court would take that into account as a,
Because that way,
Yeah.
they could hear what you want.
yeah.
And probably they can argue with that.
Yeah, I mean, in the absence of any will, someone who found that video could try to introduce it at court as your will. But, it's always safer to have like a holographic will where you just sign
Right.
it and reference the video. Like, I did a video and I took a video of how I want my property distributed and why, and then sign and date your holographic will, and then that would
They'll honor that.
honor it. Even a regular written will, you can also do that in a written will.
Because, I was thinking that if you put it in a dish, stack it someplace, and then upon that dish, don't open it until such time I died
And
or
we
passed
we always
away.
see that on TV too, right? Like
Yeah.
they'll always play it in like a
Yeah.
movie where someone passed away, and then they call the family, and then they play it in front of everyone. But the problem with that, it's not really established under Guam law. But I mean, if you do something like that and you change your mind later on, then it.
No, but, if a person can't write,
Oh, yeah, if a person
it's
can't
best that you go out speak, and even in tomorrow, whatever language, just say out there, this is what I want.
Yeah.
So the children, goes to whoever you want to,
Yeah.
goes to my neighbor or maybe my dog.
And even for
Okay.
individuals who can't write,
Yeah,
but
because some of them,
they're
they
able
don't
to
know how to
comprehend
write.
and everything, and they're competent. Notaries can do an affidavit by or a will by fingerprint,
Oh.
or so there are other ways of documenting. But I mean, that's a really good idea to do a video.
Video, yeah.
And if you're not happy with it, you can always delete it, right? And then
Yeah, it could
hopefully no
always,
one will.
put it in a safe place, and this will, because everybody's on computer.
Yeah.
So, I send it to my children. Probably everybody get a copy on it. I don't care who has it, but at least they have a record.
And I mean, it's like I mean, I would think it would be like a holographic will, but because holographic will is in your own handwriting, right? But if
Yeah.
it's in video in your own oral language, it's kind of like a writing is just what you.
Writing is good.
It's a visual version of your speech, basically. So maybe it'll work.
Yeah, but, but you said there's no,
But yeah, there isn't really
They
a
haven't
Guam law
applied to
specifically
Guam?
on it, but I'm pretty sure it would be acceptable if it was incorporated by referencing your either a holographic will or a written will.
great, yeah.
So if you can draft a holographic will and say, I want these items to be distributed according to this video that I produced on this particular date, and maybe have a copy of it attached to the holographic will, that would
That
be
would
the
be
best,
honored.
the safest way really of making sure it's complied with, okay? And so like a holographic will, this is like a quick fix where you don't want to pay for an attorney or you don't have time to meet an attorney. And all it is it's a will that you put in your own handwriting, and you can't type it up, and it has to be written, dated, and signed by in the hand of the person who of the person who's wants to give the items away, the testator, right? S- Well, the type. Well, see, that's the main con of a holographic will, because then your children could say like, no, that's not mom's signature, or that's not mom's handwriting, and then they'll have to introduce, they'll end up being a
But
contest.
it doesn't just, because the children, if the children are alive. But what I'm saying is, why do we have to do all kinds of those things for the children, and they can erase those things. It could be, excuse me,
Oh no, I
it could
understand.
be fabricated, so that it,
And I think that's why the legislature passed a holographic will. I mean, it's basically from common law, but it allows someone to, do it without a lawyer and without any witnesses. So like if there's a lot of conflict among your children over who gets what property, and, you don't want to deal with it, you can put it in your own handwriting, and no one will ever.
so do you have that simple, just forms that we can access from you?
Yeah, I could give a list of,
You don't.
I could create a checklist of things that would need to be
Just
in a
to fill it in,
holographic will,
so that when
just to
we,
make it valid. And a holographic will, you can still submit it to court,
thank you, my dear.
so that a court would hold on to the will for you. So, because if it's a holographic will, there's only one original. And so if someone, finds it and disagrees with it, they
It's
might
good,
tear it up.
like, if we have a workshop, like, I know that this is a very special social hall, but if we can only have, a workshop, like, here are all the forms, and we can grab some of those forms and duplicate it ourselves, and then we start from there, and then we need guidance from you, we can go through you, rather
Okay.
than, because there's so many, if we have to go down the line and keep mentioning about what they want and what they don't want, why don't we just have the simple information that is needed for the family or extended family, whatever it is, so that anybody who wants to challenge it in court, and that's not my problem because I'm already dead.
Yeah. No, that's a
So
good
if we
idea.
can, if we can have that
We'll-
simple,
we'll work
simple
on something
assistant,
like
my
that.
friend. All I'm
Yeah.
asking is simple assistant. I know you've got so many things, and I know why that arrived, to you, because there have been many complications in during the whatever completion of all those things. But all we need is like when I went to Las Vegas and I found it on the counter, that
Yeah.
they're selling I bought that, but it does not, and it's very easy to have it down. I even have it there, but I just wanted to find out what this presentation have to do, and
Yeah.
I'm voicing it from my own opinion. I want it simple,
And
and
I-
whatever is complicated, we can challenge that complication, but simple so that if we die tomorrow, we finish it, whatever we want to finish, very simple.
No, I mean, that's a great idea. I know that, for peace of mind, it would be easier and faster if you could just do it
Yeah.
yourself. But I think it's always wise to just talk to a lawyer so that they can catch things
Yeah,
that
but
you
we
might
have
have
to
missed.
pay for the lawyer.
But
Again,
I know that's the problem. But don't
That's-
worry,
that's the
I'll
help
help you
that-
with your stuff
too
after
often
this.
that, my friend, I really,
Oh, sure.
Since you brought up the holographic will, so in other words, it doesn't have to be notarized?
It doesn't have to be notarized, as long as it's in their handwriting. And the good thing about a holographic will as well is, it's a good way of like listing all your different personal property and saying who it goes to. So if you ever make any change, you just have to make sure it's in your own handwriting. So it's like a living document, like you can just, update it every now and then. It's the easiest will to update, right? Well, see, a holographic will, you can just keep adding things onto the end or striking things, like,
it's supposed to be dated, right? When you
yeah, it
write
has to be dated.
Oh, so if you're gonna revise it or anything, you have to put another
Put a
date on
new
it?
date, yeah.
Oh.
And so you can even make a next page and say, this is like an attachment to the other will, to my main holographic will, and you,
Because if you're gonna keep writing on it, it's just page 1, page 2, can do that, right?
yeah, then just
Just
add a
page 1,
page,
page 2, and
and then
then
add a
just sign
page
your
3,
name?
yeah.
Okay.
And did it. Just-
My name is Dorothy Garcia. I understand that I'm still married, but what I want to know how I'm going to do this. That if like for example, I'm getting old already. I want my kids, my daughter, to take care of me, and I want my daughter to take care of everything, like if I'm sick, I'm at the hospital. That's all I want for a paper to, for me to assign my daughter what I want for her to do. On me, I know I have a husband, but, my husband is not a Guamanian, so I don't,
And
all I want is make a paper stating that if anything happens to me, I'm sick or what, if I pass away, my daughter have to take care of everything.
okay,
That's
so,
all I want.
and that's our next topic is
Oh, okay.
advanced directives.
Uh-huh.
And I'll just move on. So an advance directive is like a durable power of attorney for healthcare, or a living will, or do not resuscitate. Does anybody have any of those things? A living will, a do not resuscitate form, or a
No, I don't have.
durable power of attorney? Okay, so a durable power of attorney, if you become incapacitated, a durable power of attorney will authorize that person, like in your case, it could be your daughter, to make decisions for you regarding your medical care.
If I'm, like,
So,
if I'm,
like if you need additional surgery, you could authorize that in
well,
a durable
well,
power of
right
attorney.
now, I make my own decision.
Oh, no, no, yeah. So,
Yeah,
and that's the
but
thing
what-
is, a durable power of attorney will take effect once you're unable to make decisions for yourself, especially for healthcare. So any power of attorney, right, you're sharing the power, but a durable power of attorney, once you're incapacitated, that person will be able to make those medical decisions for you. Okay, especially if it's a durable power of attorney for healthcare. So let me go into that. So Guam has, well, we have, one thing is it's basically called the Natural Death Act, and that one allows a person who's incapacitated, they have to let the medical care professionals know in advance that they don't want life-sustaining treatment. There was this famous case, Terry Schiavo, who was in a coma, right? And her husband decided that he knew that she didn't want to live that way, and he wanted to remove her feeding tubes. He didn't have a living will, so he tried to make that decision for his wife. The parents of Terry Schiavo did not want the feeding tube removed, and so it ended up being this long legal battle that took let's just say she had her stroke she was in a coma in 1995. She eventually died in 2005. So, and throughout the whole time, there was a legal battle over whether or not she had a right to die. So Guam has the Natural Death Act, and what it does, it allows you to make a decision before you're ever incapacitated as to how you want to be treated, like if you're in a coma, if you're in a situation where you will not recover, right? And it has to be two doctors who make that determination. So if two doctors say like you're in a coma or you're at that point where no medical treatment can have you recover, it's just a matter of you dying, then you have a right to withhold certain It's called life-saving treatment, okay? And Guam's law is actually kind of interesting. It's life-sustaining treatment. And on Guam, life-sustaining treatment includes any medical procedure or intervention that, when administered, will serve only to prolong the process of dying or an irreversible coma or persistent vegetative state. So, for example, if the only thing keeping you alive is like a feeding tube, in most jurisdictions, right, that's considered life-sustaining treatment. Yeah. And, I pulled out the form that GMH uses, and I think we have that here. Maybe all of you can get a copy. You have the. Did you guys all get this form? The declaration regarding the withholding and/or withdrawal of life-sustaining treatment and procedures. Okay, so what this does, it allows you to make the decision as opposed to your children. Like when my father was in ICU, the children, all of us got together, and everyone has their own opinion, and my mom, and it's like that's decisions made in that kind of environment are really never fully thought out, and it really could lead to some serious conflict, right? And so it's best if the patient is able to make those decisions in advance, right? And so this declaration regarding the withholding and/or withdrawal of life-sustaining treatment gives you that power to make those decisions. And so the form that we have here, it's printed from GMH's website. You just you print your name, and then you indicate that you're of sound mind and at least 18 years old, and that you specify that if you have an incurable or irreversible condition diagnosed by 2 physicians that will result in death within a relatively short time, that you can specify which treatment you want to be withheld, including, you don't want CPR, you don't want to be put on a kidney machine, dialysis, you don't want to be put on a breathing machine. And those are the things that are considered life-sustaining treatment. I'm not sure, but if a doctor prescribes it, I think they could still.
What if you signed this and you changed your mind about something? Like, so you were still conscious and you didn't want to be on a kidney machine, and then you decided you did want to.
Well, then you would have to, what you ordinarily do is you give this to your primary care provider, and then if you're still conscious, you can revoke it, but you have to let the doctors know.
What if you don't have a primary care provider?
Or the doctor at the hospital that's treating you. Hopefully you're conscious enough to
So you could have, this would come, later we'll get something like this? We don't have
that's
to,
a form that you could fill out.
but
You should fill it out in advance before you're.
But we'll probably lose it by then. I mean, it might be 5 years from now. And you know how it's hard to keep order of everything.
Mm-hmm.
And over the years, with all the typhoons and termites we have.
Yeah, and so that's why, like, I talked earlier about the durable power of attorney. So a durable power of attorney can work along with.
Can we change it at the time?
Oh, you
if
can
we're
change
conscious?
it every time, yes.
Yeah, okay. I'm sorry. Thank you.
And so this form allows you also to say that you do not want tube feeding for nutrition or hydration, which, I mean, I'm a lawyer. I don't think that the Guam law allows a doctor to withhold it according to the definition here. So, because if you look at the definition of life-sustaining treatment, it specifically excludes pain medication, nutrition, or hydration. So while the form allows you to withhold tube feeding, I'm not sure if the law actually insulates doctors, but unfortunately, many jurisdictions include tube feeding as part of the law, but Guam, for some reason, did not include that. So it's kind of a gray area. No, you just check each box that you want. Yeah, this is a form that Or you could like sign it in advance and give it to someone you trust to comply. Yeah. And that's why like if you have a power of attorney, usually who you give your power of attorney to, you give them this form also. And especially if they have a durable power of attorney. So like a durable power of attorney can also, they can make decisions for you when you're incapacitated. But if you want to make sure that they comply with withholding life-sustaining treatment, then you also should do a living will and specify that the living will control what your agent does. For example, like in that Terry Schiavo case where she was in a coma for 20 years, if she had a living will that said, she had a durable power of attorney, right, for her husband, and a living will that was consistent with what his wishes were, then he would have been able to have the feeding tube removed a lot earlier. But because he didn't have a living will or a durable power of attorney, he was not able to make those decisions.
Do we have to make the living will ourselves, or somebody will prepare the living will for us?
Well, this is a form that you can do by yourself, but you do need two witnesses, and the two witnesses you need should not be, well, it says here, it can't be anybody who's works for a community care facility or the hospital, so it
Then
would have to
how-
be, and it, and also to
And
be.
it has to be notarized.
No, it doesn't have to be notarized.
Okay.
And it might also be safe to make sure it's not someone who's going to be,
Because
an
I
error.
was looking at the bottom here, it says there's a batch number. So this form is only good for the hospital, right?
yes, this is a
So
hospital
what are the
form.
forms we need to keep in our files?
Well, this is, you could keep a copy, but then give a copy of the original to the hospital.
Because this is confusing.
Which part is
Because the numbers on the bottom, see, and what I wanted to do is, upon my signature, or this form, I want it notarized. That is going to be, probably somebody will keep it for me until such time that I become ill, and they'll honor whatever my wishes is. But right now I don't know whether this is going to be a good form to keep or.
Yeah, this form, I mean, it was a form on GMH's website, so they should accept this form as long as there are witnesses.
But you don't have to be notarized.
But it doesn't have to be notarized.
Because nowadays, it says to be legalized, you have to have it
Yeah, I mean,
notarized.
if I was doing the form, I would have it notarized just to be safe. But
Yeah,
for some
because,
reason,
they ask you whether this is, who make the form. So if you notarize it, they have a form and they cannot deny that is, because there's a weakness right there.
yeah, that's true. And
No, but, the way I look at it, it's usually I fill this form and then I keep it and then nobody,
yeah, that's a problem. Who do you give it to? I would
Right.
give it to your medical doctor.
Yeah, but it looks like this form is good only when you're hospitalized, right?
Yeah.
So.
And that's why we also recommend you get a durable power of
according
attorney,
to here,
so that
it says there's a
that
batch
person
number.
who has your, if you,
If you have this, then this is what I
yeah,
say. If you have the
I
durable
used to
power of
work for
attorney.
the elderly.
Then this,
I used to work for that elderly. And all the client that I go to their house, they have this paper on their wall. But yes, I understand this is the paper that they fill in, because the patient, they do this for her because because if she's already sick, and then they have to follow what's on this paper. But I think they notarize the paper.
yeah. I mean, this form,
This
there
form,
isn't,
this kind of form,
And
and
it-
then that's the time they give it to them, the family members, and they put it on the house.
and really, I mean, it's much better is notarized. That way it happens, because, like if someone's gonna challenge a living will, it'll probably be one of the children, and their first challenge is gonna be that mom was incompetent when she signed it. So,
Yeah.
a notary would be able to make sure, and the witnesses also would make sure that she was competent at the time that she signed the living will.
Incapable of putting anything down. Um, And there's no funds. How is it paid for?
Well, that, yeah, I know GMH is a public hospital, so my understanding is that they'll just take care of them until they.
But now they're already in a huge deficit, so who would be paying for it if the person didn't sign this? How would they fulfill keeping somebody alive on dialysis is very expensive, or whatever this is, if they didn't sign, if they have no money? And,
Yeah, well,
and the
that-
family's not willing or able to put the money there, how would they keep a person alive when the hospital's in a deficit already?
Well, I don't have the answer to that question, but I'm pretty sure GMH would just keep treating them. They can't really just push them out.
But
out the door.
they're already almost losing accreditation, and there's such a huge deficit, it's
Yeah.
going to be impossible. It doesn't seem like they'd be able to even do this unless the family has money. So wouldn't that be something that might have to be considered here?
Yeah,
I
well,
mean, that's the basic thing is, doctors have to get paid. They can't work for free.
yeah,
The
I'm not,
government's broke.
I'm not sure how GMH would resolve that, but I'm pretty sure they wouldn't just, like push them out the door.
What can that,
But there
even if they don't sign this, how is it possible that they could do all these things for them without money? If the person has no money, it doesn't even account for anything to do with that on here. So this is kind of moot subject if there's no money behind anything. You say they can't, but they may have no choice if if the hospital can't pay their power bill, and they don't even have the dialysis, they don't even have electricity to run it. They've run into deficit because the people can't pay this. Shouldn't there be something in there about how this is going to be covered? What about the rest of the people of Guam who are, young people who need to stay alive, and they're putting all this on people who didn't sign this paper? I'm kind of wondering, it's not congruent with reality.
Yeah, sorry, I don't know the answer to that question. But, and so the living will, this is just a basic one. There are other living wills or durable power of attorneys where you could add provisions like, a lot of us might have children off island, so, you want your plug pulled, but you want to give them a chance to make it back to Guam. So sometimes you could say like, after 5 days or after 7 days, then all life-sustaining treatment can be withheld. So you could put conditions on it like that. You can also indicate like if you want your organs to be donated or not donated, you could also specify that. You can also indicate that your desire is to be released from the hospital and that you be allowed to die at home. So I know that sometimes the hospital might be reluctant to, but if that's part of the living will, then, of course, they will release you to the family so you could die at home. Okay, so that's basically a living will advance directive, and Guam has a good law, but I think it needs a little tweaking just to make sure that you can withhold nutrition and hydration. When it was passed, it specifically excluded that, and so the form GMH provides allows you to withhold it, but I don't know if that's really legal, if the law doesn't allow that. So maybe that's something that needs to be addressed. Okay. Oh yeah, you can do that. Fill it out, but you should have 2 witnesses. and give it to your primary doctor.
This is the truth. Because I used, I worked before. So there's too late. There's somebody came to that client's house, and I think she have a paper like this, and the nurse. I think that's the nurse or somebody else. I don't know, lawyer or what. So they asked me whether I can sign to, to witness the paper, to sign the paper for that old lady. And I asked them first, do I have to be, in trouble if I sign that paper? And she said no. They told me no,
But who did you work
because
for?
it's just Catholic Social Service.
Well, I mean,
But
the law doesn't permit like if you're in a residential facility like SNU or St. Dominic's, they're not
No.
allowed to be witnesses on a living will. So that's kind of
no,
interesting.
because they asked me whether I can sign it because they need somebody to sign it. I said, no, I don't think so. I need to sign this because I don't know anything about this. You know?
Yeah.
So that's why I'm asking whether I can take this paper and ask the doctor
Yeah,
what.
and you could provide it to your doctor. And under the law, if a doctor refuses to abide by your
No, just
living
to,
will,
you
then they
know,
can.
no, but just to find out what's going on with this
Yeah.
paper, because we're not going to
I
sign
think
it until
they'll
we.
probably need to update the form. But really,
Yeah.
so like if some doctors will not withhold nutrition or hydration. So, and if you want that, um,
But it's no.
then there's
It's no
provisions
use.
that allow them to.
So if this paper, it's no use signing, putting that only one thing here that you don't want. If you're already sick, and you don't want the machine, the what you call that,
The
and
breathing.
that's all you don't want there. So what they're gonna do with the rest?
So,
They're gonna.
no,
they're
that's
go-
what I mean. If you only check one box,
Yeah.
they'll still give you all the other stuff, hydration, nutrition. They'll still
That-
do CPR
That's what I'm saying.
unless
That's
you
what I'm
check
asking.
each of the boxes.
That's
No.
what I'm asking.
Yeah.
Do you have to fill in everything here? Check mark everything here?
Yeah,
Or,
just check
only
mark the
one?
ones that you want them to withhold because some people, for example, like the tube feeding for nutrition, some people would not elect to have that withheld. So they'll check all the other boxes. Because, I mean, that's kind of it's a hard thing to
it's hard to
have your
decide.
children, watch you basically die from
Yeah, it's hard to decide to.
dehydration or
Yeah.
starving to death. So that's why some people would not elect that. Okay. So hopefully all of you will at least have, I gave you some ideas and you can get help in at least doing like a durable power of attorney or a living will or even a will. It's not a very complex thing that should cost a lot of money. And, you guys sure I'll help for free, right? But it's something that'll really give you peace of mind. Yeah, that's the form for the living will that the GMH. Yeah. Oh, like living will. A living will is really like a do not resuscitate and. Okay. Okay.
Thank you. I missed the session earlier regarding probate. Can you challenge the probate if it's closed already?
So
No.
that one you'll need to see a probate lawyer about. It gets really technical.
Okay.
So-
And is there a statute of limitation if there's a clause to comply or something?
Well, they have different statute limitations for different causes of action. Like if it was fraud was involved, then it might be 3 years. But Yeah, those are real specific questions. You should talk to
Probate lawyer.
yeah, probate.
Probate lawyer?
Well, I know that the Guam Bar has a referral service, so they have a
Okay.
list there of attorneys with their specialty. So,
How can we check out the attorneys to know if they're honest? Is there any kind of review from former customers?
yeah, I know they have that on, they might have something online. I have no idea. But generally, if they're on the referral service, then the Guam Bar has,
I checked, it happened before when I checked it, and then they had been.
Some of these lawyers cannot be trusted, especially with senior citizens. They really take advantage of us. And there's so many dishonest lawyers, I found out
Yeah.
through personal experience.
yeah, I'm sorry to hear that. But hopefully, you can find one that you can work with. But, just call me. I'll give you as much advice as I can.
Okay, what's your phone number?
Uh,
What's in?
yeah. Okay.
So
But,
the
I'll have
first-
one of my
is this
staff,
it?
like, get names and numbers, so I'll call you guys.
Is this
okay?
your number on the back?
Well, that's our general office number, but we'll get your name and number and we'll call you.
Oh, thank you.
But do you guys have any other questions about any of the topics?
Thank you. Not so much about a topic, but just about maybe it is a topic. It's on legal services for the seniors on Guam. So I first and foremost want to thank Senator Shelton and also Senator Biscoli, who was here earlier. And thank you, Stephen, Attorney Hattori, for your presentation on legal topics. But I guess what I really want to ask you, Attorney Hattori, is how many attorneys do you have with the Public Defender Service Corporation?
Right now we have 14, but we'll have 16 in the next couple of weeks.
And I think this is just a small sample of the seniors who are here today. There are many more seniors who need legal services, and they go anything from powers of attorneys to wills, deed of gifts. And I guess, is there any way that the Public Defender Service Corp can revisit the moratorium so that they can become a partner in a greater degree to provide legal services to the seniors of Guam? Is there anything that can be done through the legislative level,
Well,
perhaps?
that's what, we've been working on that for years. I've only been the director since 2016, and when I, first came in, that was one of my missions. But right now, it's just a matter of convincing our board that, we're ready for it. So I think we just need to convince them a little more. So we're working on it. I can do stuff pro bono, but officially, we can't really open our doors to the seniors office wide just yet.
And I also want to
something
thank
we're
you for
working
that,
on.
because today, the seniors that are here are being provided through your support, pro bono services, and so there's probably more seniors are going to be calling our office to ask, well, we'd like to get on that list too. And so if there's anything the PDSC or perhaps even Senator Shelton in her capacity as the committee chair on senior citizens could look at and how we can perhaps revisit the current moratorium on the Public Defenders Corp so that perhaps as an entity, along with the Micronesian Legal Services Corp and the Guam Legal Services Corp, Disability Law Center, these three corporations that are community-based, if you could continue to work on moving forward to open your doors, even more so, to assist the seniors, I know that they would most greatly appreciate. And I think this is a small testament, a small sampling of all the seniors who are really looking for legal services. And just as you talk about the different types of options they have, it's just that. You hear about this option, but what's the impact? And then when do you change it? How do you change it? How do I keep it current? These are the realities that the seniors are dealing with. And if you can do anything, along with Senator Shelton, as advocates of Guam through the Division of Senior Citizens of Public Health and Social Services, that we know the seniors would most appreciate it. So thank you very much, Attorney
Okay, thank you.
Hattori and Senator Shelton.
Speaking for myself, it's really frustrating when people come to our doors and they would ordinarily qualify for our services, but we can't help them. So, I really want to help the seniors, and hopefully we can make something happen. Our plan was to team up with Guam Legal and Micronesian Legal, and then there would be like 21 attorneys
Right.
available to assist the seniors. And so, I think it's a program that if we get up and running, it will be very effective, and it'll benefit the society as a whole, because our goal really is to, of course, ease the mind of the seniors, right? Because this is a very stressful subject for them, right? But also to prevent future conflict among the children, those left behind,
Right.
so that there's less conflict. So we're working on it. Hopefully, we'll get there.
Yes,
All right.
I know. I know where your
In the
point is,
meantime,
but
I'll help the ones here, since you
Yes.
guys came down. We'll get your name and
does
numbers.
does that extend to everybody or just the seniors?
The seniors?
I was just wondering, does it extend to everyone? I'm just-
You don't need help, Art.
Is this only for seniors whose household income does not exceed these limits here?
Well, see, I know that the seniors division has a contract that they don't look at income, and it all depends on if we're able to get the grant. Like, for example, right now we do protective orders that is not income-based. So if you're a victim of domestic violence, but you're overqualified, otherwise we would still, because of the grant, we would still.
But what about for the advice that you're telling us?
Well,
There's
that
still,
one-
if your
I'll-
household, if there's other people in the house?
I'll
and-
just help you like pro bono on that one for now.
Okay,
Okay. Oh, sure.
thank you so much.
Well, just the seniors
Attorney.
that came.
Torres. Thank you.
Yes.
Jennifer.
Okay. Well, yes, at this time, yes, Attorney Hattori has offered to help most of you who came down here on his own, but we know that we are trying our very best as a legislative body to allow for the Public Defender's Office to assist senior citizens in a more expanded capacity. So we are working very diligently to do that. And I'd like to just take this opportunity to thank the public defenders for coming down here today and offering this informational hearing today for all of your legal questions and to help with things that you may be facing on a day-to-day basis. And of course, for our senior Division of Senior Citizens for being here to answer any questions as well. So I now will just invite Mr. Hattori to speak with all of you offline, because we are going to use the public hearing room for another event starting at 12 o'clock. But I think he's gathering all your phone numbers, and we just want to let the public know that they can contact the Public Defender's Office as well. They're located in Sinajana, and if you want to say your phone number.
Our phone number is 475-3100, but currently we're only doing like encompassing guardianships, regular guardianships, and protective orders, and things like, I guess, bury body cases. I didn't discuss that today, but hopefully in the future we'll be able to do more.
Yes. So thank you very much, everyone, for attending today, and this informational hearing is now adjourned. So Situas Masi.